So again, everyone, welcome this afternoon to Your Hour with APA Virginia. My name is Martina James Nally, and I am staff with the Virginia chapter. This month's webinar, again, is brought to you by our generous sponsors, the Berkeley Group, who make this webinar series possible, so thank you to them. A primer on thank you to them. A primer. A primer. 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 Thank you to them. All right. Sorry about that. We had a little bit of feedback going on. But a primer on Proffers is being presented today. Thomas Skuzinski. I hope I didn't butcher that too much. We'll be talking to you guys this afternoon, and towards the end, we'll leave some time for questions. As always, this presentation is being recorded and will be put on our YouTube page. Afterwards, we'll send out an email with that link so people can go back and do that. It'll also have the information to claim your CM credits for the presentation. If you are listening live, you're able to do that. And if anybody has any questions, feel free to reach out to the chapter. All the chapter's contact information is on our YouTube page, as well as all our previous presentations. Thomas, I'm going to hand it over to you. And as I said, at the end, Thomas will let you guys know when you guys can ask questions, and you can type them in your question box below as the presentation is going on, and we will check in with those at the end. So Thomas, thank you for joining us, and I look forward to hearing what you have to say.
All right, thank you, Martina, for coordinating all of this, and I'd also echo her thanks to the sponsors for making this possible. And of course, good afternoon to all of you. I'm guessing based on the time that a lot of you are doing this over lunch, so thank you for trying to learn about Proffers over lunch. I know that it's probably not the topic that might seem the most interesting to deal with over your lunch hour. Just a few things. This is intended for a general audience because of how different conditions are for all of the different localities that you work with across Virginia. I really wanted to have this presentation be sort of set at a level that would be accessible to new practitioners as well as to people all across Virginia. And obviously, this is covering a topic that does apply across all of Virginia. So if there's anything that seems like it's not really applicable to you, just be patient with it, and I think you'll find that most of what we cover is actually meaningful to all of you in some way. Secondly, this will emphasize the changes that have been brought about by the passage of SB 549, the Proffer Reform Bill last year. We're just over a year out from the passage of that, but there's still a lot of confusion about it. A lot of things are still in flux. We haven't really seen any litigation of any of the major issues with regard to that statute. There's also some terms that were never really clearly defined in it. So just bear in mind that a lot of this, as I said, is in flux, and my ability to give you really concrete advice because of that is somewhat limited. Also, just in general, this is not legal advice. So in the Q&A, I won't be giving answers to very fact-specific questions. I can give advice and suggestions. I'm also happy to kind of look things over and think about them by email if you have some more specific questions. But I would emphasize that it's really important to be working with your local attorney, whether a staff attorney or someone you have on retainer. They're likely to have a lot more knowledge of the detailed circumstances that you've been working in. In Proffers, it does matter somewhat what the history is in terms of how your locality has been dealing with them historically. So that's why I do, again, just emphasize work with your local attorney and take everything that I'm providing to you today as sort of a baseline for gaining understanding and maybe seeing what the red flags are that you should avoid and what you might be able to do to respond to the changes in the law. All right, so the presentation will have three basic parts to it. First, we're going to cover conditional zoning in Virginia. So that's really intended to give us a historical baseline of what were things like before summer of 2016, before the Proffer Reform Bill took effect. It's useful to understand what that baseline is so that we can actually appreciate just what did change and maybe what didn't change after the passage of that bill. We'll then go through parsing the 2016 Proffer Reform Bill. So looking at some of the key terms in it, and trying to help you unpack what those might mean for you. And then lastly, we'll have a section on how to respond to that proffer reform bill, how you might have to change the administration of zoning and planning in your community. So let's start with just an overview of what is a proffer. Okay, what does conditional zoning in Virginia cover? So this term proffer is something that's unique to Virginia. It's a reasonable condition that is voluntarily offered by an applicant in a rezoning process to mitigate rezoning impacts. All right, and so that's a very basic definition. And so let's go through what some of the terms in this mean first. So by rezoning, this does not apply to by right or otherwise permitted development. So this is something where, for example, a change needs to be made from agricultural to single family residential to allow a subdivision to be built. When we talk about conditions, what do we mean? Well, mainly it's related to public facilities. It might be monetary contributions, property dedication, agreements to build facilities, or other actions such as that you will phase the development to mitigate the impacts brought about by rezoning. What do we mean by voluntarily, or what was historically meant by this, is that the government cannot propose and require a proffer as a condition of granting approval. And we'll unpack a little bit more what this means and kind of what the nuances between what would be voluntary and what would be involuntary. And then reasonableness, the rezoning action must give rise to the need for the proffer. And there must be a reasonable relation between the proffer and the rezoning. And those two aspects of what it means to be reasonable actually mimic somewhat closely federal jurisprudence on unconstitutional conditions. And I'll talk about that in a moment here too. So when we say that it must give rise to the need for the proffer and that there must be a reasonable relation between proffer and zoning, what that mirrors is this idea of there being an essential nexus and rough proportionality that we see in Supreme Court opinions from Nolan and Dolan. For those of you who went through planning education, whether as undergrads or grad students, this will probably seem painfully familiar to you. So when we say rezoning must give rise, that mirrors the idea of there being an essential nexus. It can't be that the rezoning is causing something to happen and then we're having a proffer that's just not related at all to it. So one of the classic examples that I often give people is if this is a retirement community, for example, it would not give rise to the need for new school facilities because you're not expecting that an elderly community would add students reasonably to public schools and burden them in some way. So that's just a very simplified example. There also must be a reasonable relation between the proffer and the rezoning. So this is this idea of rough proportionality, that the locality must be able to express and substantiate somehow that what they're asking for in the proffer has a relationship to the rezoning. I know a lot of the localities that you're working with might have cash proffer schedules, or they might have other guidelines for what would be expected of a new development that's being put in. And so that's part of why we have that, is that we want there to be that rough proportionality or reasonable relationship between the proffer and the rezoning that's happening. And then this does extend to cash as well at the federal level through the Coons case. And it did historically in Virginia. So this is, if we look at this from a developer perspective as well as from a locality's perspective, this is sort of a baseline idea of fairness, that if a development is going in, we want whatever is being done to mitigate the impacts from that development to actually be connected to the action that the community is taking. So if we're going from agricultural zoning to single family residential zoning of a certain density, we would expect that there's impacts that a community can estimate from making that switch. Maybe it's adding 80 or 100 new units of housing, for example. This obviously would work in the context of commercial rezonings as well. That there's an idea of what the impact is from what's going to happen, and that we expect there to be some mitigation of that impact specifically, not just of generalized impacts in the rest of the community, or not of some impact that's happening that's completely unrelated in any way. So let's go through a simple example with a cash proffer, and this is a pre-reform example. So in a moment, we'll be switching over to what the new statute says. So let's imagine a developer proposes a 50-unit single-family detached residential subdivision. It would require rezoning from agricultural zoning to single-family residential. The local government has in place a method for calculating per unit demands on public facilities from new residential units of different types. So is this reasonable? Like, are we heading down this path of reasonableness? Well, likely yes. The rezoning will generate impacts on public facilities. A cash proffer would allow, for example, new facilities or expansion of existing ones to address that impact, so we get that essential nexus. And the cash proffer schedule is based, hopefully, on a defensible estimation method, so we get that rough proportionality idea. Now, is it voluntary? Well, that's going to depend. We have only a handful of cases in Virginia that can help us suss out whether what we're expecting from the developer is voluntary. So here's an example that wouldn't be voluntary. You have proffer guidelines that recommend a payment of $5,000 per unit. No rezonings have ever been approved without meeting the recommended minimum cash proffer. The rezoning would meet all the other requirements. It's in accord with the comprehensive plan, and there's been some kind of communication to the applicant that the cash proffer is expected. This is looking very much like it would not be voluntary. This mimics the facts that were present in the Reed's Landing case in 1995. And the reason that it's not voluntary is that the proffer is basically acting as a conditioned precedent for approval. There's a direct quid pro quo. You might even have a problem where a locality says, as when we go to litigation, that there was an expectation, yes, that whenever a new development would go in, that this minimum payment would be met. So when you have that case of there being a cash proffer on one side and then an approval on the other, and there's no flexibility in place to wiggle around that, then that's where you're going to look like you're not behaving in a way that's voluntary. Now here's an example that looks much more like it is voluntary. You have, again, the proffer guidelines recommending payment of $5,000 per unit. Rezonings have often been approved without meeting the recommended cash proffer. So maybe there have been some that come in just a little under it, or maybe sometimes other things are done instead of cash payment. Rezoning would cause identifiable impacts that are not otherwise being mitigated. And there's a communication to the applicant, not that the proffer has not been paid and that that's unsatisfactory, but rather that the impacts must be addressed. So here we're resting much more firmly on a foundation of zoning law principles, that you're trying to advance the public interest, that your concern is with impacts not being addressed, not with the fact that your specific proffer schedule was not being met. And so that's where we start to look like things are more voluntary. There seems to be an option now where the developer can either pay the cash proffer or do other things, or just take the risk that maybe their attempts to persuade within the process are not going to be effective and they will have the application turned down. But it shouldn't look like it's an inevitability that the application would be denied. So the reason I go through this example is that even before the proffer reform bill, and I think a lot of you will appreciate this based on the work that you've been involved in, a locality has to be careful in its administration of proffers. You should be substantiating and documenting in writing in the records for all proceedings the impacts from a proposed rezoning and what can be done to address those through proffers. So both of those things have to be in there. The applicant or the owner, I say applicant / owner here because especially under the new reform bill, it's very specific that this has to be the owner, and this was the case before. So for example, someone has to hold a fee simple perhaps, and they also have to have the authority to be able to engage in the process. And so they're deciding what to proffer, that there's some voluntariness left with them. And then if there is a denial, it has to be based on zoning principles, such as unmitigated negative impacts, not simply the failure to proffer. So there was some need for care well before 2016 and the reform bill came into effect. So now let's actually go into the proffer reform bill. Not going to pull the whole statute out here and have like the language of that. There's plenty of links to that on the internet. So look up SB 549 or proffer reform bill and you'll be able to find it. I really wanted to pull out the key terms in here and try to give you a very sort of layperson idea of what exactly is going on with this proffer reform bill, because it does actually change quite a bit. So first, let's look at the coverage of it. Only applies to either rezonings or proffered condition amendments, what I'll call PCAs from here on. Only applies to new residential development, and that includes residential portions of mixed-use projects. So this doesn't apply to commercial development. It doesn't apply to any other actions that might be taken. And then this is a really key point. It's prospective in its application. So the act came into effect on July 1st, 2016. And there was some concern that I'd heard about, that there was an issue of, might there be reach back through the proffered condition amendments, so that a proffer had been decided, and then after this took effect, now after July 1st, 2016, there's an attempt with the PCA to go back and upset the proffer that was in place. The PCAs under the statute actually can only be those that apply to rezonings or to proffered conditions that were done also after July 1st of 2016. So there isn't a concern about reach back based on this, and so that shouldn't be an issue for you. And lastly, the aggrieved applicant must act within 30 days. So that's a pretty tight time window. But it's, we would presume that a developer would have some awareness of this having gone through. There was a lot of involvement by the development community with the passage of the Proffer Reform Bill. So just bear in mind that 30 days is kind of the magic window here. There's also 3 exceptions, and this isn't going to be meaningful to most localities in Virginia, obviously. But I just wanted to walk through these really quickly. The first one is the one that might be the most applicable in terms of breadth. New residential development or use that's within an approved small area comprehensive plan, designated as a revitalization area, encompasses mass transit, and has mixed use with some FAR of 3.0 or more somewhere within the area. So this is, you can see that this is getting at the idea of these revitalizing areas that maybe, there's an interest in the legislature of not having quite the same onus being put on these. Similarly, within approved small area comprehensive plans that encompass an existing or planned metro rail station, or that are adjacent to one in a neighboring locality. So there's 2 possibilities there, and that allow additional density in the vicinity of the station. And then the third exception is for new residential development or use that's within an approved metro rail service district. When you look at the statute, you'll actually see references to other statutes in Virginia that give you an idea of like what's a metro rail service district. What do some of these terms mean within here? And I'm not going to cover those now, just because I recognize that not every locality is going to be immediately involved with these exceptions. So then let's get to the language, like the basic idea of the Proffer Reform Bill. It's that you cannot request or accept any proffer that is unreasonable. So at a baseline, and again, this applies only to new residential. It applies only after July 1st of 2016. Everything that I just got done mentioning about exclusions, if you're within the ambit of things that this bill applies to, then there cannot be request or acceptance of any proffer that is unreasonable. So let's go through specifically what unreasonable means and then what request means. So lawyers, I guess, like to use very vague terms because it gives them some flexibility, and it allows the judiciary to kind of flesh these things out, hopefully in a way that's in accord with what the intention was behind the legislation. So when we see a term like unreasonable, that's necessarily going to be made more understandable through litigation that will arise. And hopefully none of you are part of that litigation, right? So let's, just looking at the statute, try to figure out a little more clearly what unreasonable means. So all proffers, and this is ones that are on-site or off-site, must be conditions that address an impact that is specifically attributable to the rezoning or PCA, must be related to a public facility improvement. And this is a big limitation based on how things could work with proffers before. So when it says public facility improvement, that's only for transportation, public safety facilities, public school facilities, and public parks, okay? So things related to affordable housing or to soil erosion or many of the other ways that proffers were used before no longer are allowed. Okay, so that's a pretty big change from what we had before. And does this apply to expansion of these facilities? Yes. Does it apply to operating expenses for these facilities? No, it does not. Let's look a little bit more at specifically attributable to. That actually is not within the statute defined in any clear way at all. So it's hard to say how that differs from the prior standard of that you had this essential nexus and rough proportionality, you know, that there had to be a give rise to idea in terms of the connection between the rezoning or the PCA and then the proffer that was being offered. So presumably, because this is a reform bill, there's an interest in using that specifically attributable language to sort of beef up that reasonableness requirement. But right now, there's no way we can know exactly what that means in terms of how much precision is required. And here we're thinking about, for example, when you look at a development and you try to estimate what its impacts will be on public facilities, whether what you've done historically is fine or whether there would need to be some improvement in that. And at the end, when I talk about how to respond, I'm going to have a few thoughts on maybe how you can err on the side of caution and deal with this idea of specifically attributable, just in case it is a much higher bar that you have to meet. All right. So on the last slide, I emphasize that that's all proffers, okay? So it doesn't matter whether they're on-site or off-site proffers, whether they're within the territory of the rezoning application that's being applied to a specific property or whether they fall outside of it. Now, if we look just at off-site proffers, and importantly, this includes all cash proffers, all right? So within the statute, it's very clear about this. Off-site proffers include all cash proffers, all right? So if this is an off-site proffer, it must also respond to a need or an identifiable portion of a need that's in excess of public facility capacity existing at the time of rezoning or PCA. So let's just stop there for a moment. What this means realistically is that you're going to have a very clear idea of what the base is for your public facility capacity. And I assume that most of you would have that. What's difficult about this language is that it's where the threshold is for excess, okay? So if we think of public facility capacity, is any increment above what an estimated baseline is considered excess, or is it something beyond that? So one example, you know, maybe you have capacity for 200 students, for example, and the development is going to require that there be capacity for 202 if the rezoning is approved. Is that in excess of public facility capacity? It might not be, and there's always going to be an application of reasonableness to all this, and that works on both the developer side and on the public sector side. So you would need to have an idea what your public facility capacity is, and then you would need to probably err on the side of caution in terms of thinking about what is in excess of that capacity. Because remember, if this is estimates that you're working from, then there's going to be some margin there that needs to be accommodated. And a need or identifiable portion of a need, that obviously just means that this can, you know, proffer can apply to all or part of that need. And then lastly, so responding to a need or identifiable portion of a need in excess of public facility capacity existing at the time of rezoning or PCA, and has to provide a direct and material benefit to the new residential units. So conveniently, just as we saw was specifically attributable on this last page, not really being defined, direct and material benefit is also not clearly defined, nor is the timing around that defined. So if a building permit is issued, for example, and that's when payment of a proffer can occur, a cash proffer, and no units have been built yet, then is there a direct and material benefit flowing to those units if there's no residents to actually enjoy that benefit? That's not really clear. And again, you would presume that a court would apply some kind of reasonableness measure to this and thinking about what is a direct and material benefit, but we simply don't have a lot of guidance on this. Again, this hasn't been litigated, so it's hard to say what this would mean. And so it's a valid question, and I wish it was one that I could answer for you really clearly in the presentation today. And hopefully all of you didn't decide to take some of your lunch hour to come here and with the hope that I would be able to provide that kind of answer. But this is something that's going to have to be monitored coming months or the coming years. There might also be amendments to the bill. I would guess that's going to happen at some point in the future. This happens, traditionally with legislation. We see small changes to it. So there will have to be some vigilance on your part and working through the resources that Virginia APA provides or that webinars like this can provide. And maybe in a year we'll revisit this presentation and see, what is the state of things now? Has anything changed? Do we have any more clarity? Even if something is not litigated, we can have statements from the Attorney General about how something, might ideally be interpreted. So that can provide some assistance to us. But until then, it's hard to say how the old standard for what was reasonable is different from the new standard. So now let's look at part of the bill that actually is pretty onerous in terms of how it might change the process and administration of what you do. Before I said that you couldn't request or accept any unreasonable proffer. So what does it mean to request? It's an extremely low bar. Mere suggestion is enough, and it does not need to be written even. So this means that all the communications that you're accustomed to having with an applicant, and that you will still be able to have for commercial rezonings, for example, or for everything that this proper reform bill does not apply to. When it comes to the things that this bill does apply to, you're going to need to be very careful about your communications with applicants. And when I say careful, I mean extremely cautious. So you could say things like, yes, we are studying what the impacts will be. You can't say, these are what the impacts are, and here's what we're likely to ask you in terms of proffers. Okay, I wouldn't suggest doing that at all. Should you have cash proffer guidelines? That obviously is a suggestion or a recommendation or a request that can easily be interpreted very strongly as that. So I would suggest, don't have that. If you have that in place, make sure that it's very clear that this applies not to new residential, okay? And the reason that language there about communication is so onerous is that the statute also contains a burden shifting aspect to it. So the applicant or the owner has to only prove by a preponderance of the evidence that it refused or failed to submit an unreasonable proffer. Okay, so when you think about your dealings with applicants, all they would have to show is that by, when we think of preponderance of evidence in the law, it's like 51% basically. So it's the lowest possible bar. So they just need to show by preponderance of the evidence that there was some kind of unreasonable proffer that was suggested, right? And again, this can be just through verbal communications. And that they refused to abide by that proffer, or they failed to submit that proffer. And so that's a very low bar that the applicant has to meet. And this is why there's a concern about litigation flowing from this, right? Is that the bar that has to be met is not very high at all in terms of how we think about evidence. Now, once that low bar is met, then a court will presume, absent clear and convincing evidence to the contrary, which is actually a quite high bar, clear and convincing evidence is much higher than preponderance of the evidence, that the refusal of the rezoning, for example, or of the PCA, that the refusal that the failure to abide by that proffer suggestion or recommendation or request was the reason for the rezoning or PCA denial. All right, so a court will presume that, all right, that basically you behaved in a way that was against this law. All right, and you would have to show clear and convincing evidence to the contrary. Now, as to what that means, what is clear and convincing evidence to the contrary? Again, because this hasn't been litigated, it's hard to say how high that bar is. All right. What it does mean is that there's a lot of power to the written communications that you have, both within your staff, within the different parts of government, as well as between your staff and an applicant, okay? So you'd want to be very attentive throughout the whole process to keeping records, to substantiating things, to making it very clear in a way that, you know, we're not talking about beyond a reasonable doubt, or it's a little lower than that, but in a way that would be very persuasive in litigation, to showing that this was voluntary, that there was never a suggestion of an unreasonable proffer, etc. All of the things that we've been talking about. Now, if you're found to have violated, if the applicant is aggrieved and a court rules in the applicant's favor, you can have reasonable attorney fees charged against you, and the court can order that you approve the rezoning or the PCA, all right? And that requirement that you approve would be without any unconstitutional proffers attached to it, okay? So everything that's violative, you know, that violates this unreasonableness standard, or the idea of like unconstitutional that kind of mirrors it, would be scrubbed, okay? So if there was something that you were hoping to get, whether that's a cash proffer or something else, just recognize that in the order to approve, if you actually went through and had the worst case scenario happen, you're probably going to owe attorney's fees that are reasonable, and you could have to have an approval of the rezoning without some of the proffers attached that you might otherwise have been interested in having, that could have mitigated some impacts, okay? So that kind of paints a dark picture of everything. It's obviously one that emphasizes the need for caution, especially because, again, this is early days, okay? Like it's only a little more than a year out from when this legislation came into effect, and we don't really have a good sense of the playing field yet. So strategy one, obviously, is to try to use the exceptions where you can if these are available to you. So adopting the small area comprehensive plans for revitalization areas, metro rail stations, the things that we had talked about that completely keep you out of the ambit of this legislation. If you know that there's going to be some additional burden from not being able to do certain things with residential rezonings, then you might have to think about shifting some of that over to commercial rezonings if that's within the realm of possibility for you. But again, even there, as we saw with the historic way that proffers work, you still have to be reasonable. It's not like you can just act in a way that's not in accord with the plan, or have something that does not have an essential nexus or rough proportionality. So there still needs to be those connections. Strategy two would be to improve your impact estimation to hopefully meet the standard of specifically attributable. This is going to make the work you do more difficult, because in place of something like a schedule of, where we can say, okay, per unit, we know that the impact on schools this year is going to be this. We know that the impact on roads will be this, and in a way that you can generalize maybe across an entire county or across an entire city or town, for example. You shouldn't really be doing that when you're dealing with the new residential situation here. So try to reduce the scale of these averages to smaller areas, and then recognize that you're still going to need to calculate the impact separately for each application, okay? So instead of relying on these per unit averages, that's not something that you would be able to do under this, unless some litigation happens and there's an interpretation that seems completely at odds with the intent of this legislation. I wouldn't expect that to happen. So at least for the new residential rezonings and PCAs, you're going to need to have in place a process that's much more specified than maybe it was. And perhaps some of you have been doing that already, just because there's always the risk that what you have been done might not be seen as voluntary or might not be seen as reasonable under the traditional Proffers legislation. But again, with what's in place now, you would need to just be extra cautious when it comes to residential, okay? Strategy 3, changes to process. So we've talked a little bit about these already. Cash proffer guidelines, no, okay? Again, for the things that this legislation applies to, don't use those. Separate rezoning and proffer amendment guides for applications that do or do not fall under the reform bill, yes, you should have that. This should be something you're communicating to developers so they understand why your communications are the way they are with them. And there's kind of a couple reasons for that. You know, obviously there's an advocacy aspect to this where if this legislation becomes very onerous in terms of what you're actually able to do and how you're able to mitigate the impacts on public facilities in your community, you know, there will be a need to have some kind of evidence in place and some kind of understanding from the development community or from localities that were in support of this legislation, where maybe you are able to communicate to them that this is why things are different now. Okay, like you should make sure they understand that. So separating that, also when I say that, I mean separate the training that you do for your staff. Okay. So don't just treat this sort of a one-size-fits-all. This is how we deal with all proffers all the time. You know, explain to them clearly what kind of things come under this bill and how the communications should be distinctly more cautious with regard to what's happening under this legislation. Okay, and this also means things like, you know, communicate to them this idea of burden shifting, you know, as best you can, or better yet, have the local attorney that you're working with try to communicate this to them, or use this PowerPoint, for example. The students who are going through the graduate program here at Virginia Tech and the undergrad program are all getting exposed to this guidance on proffers. So the people that will be coming out into positions in your localities around the state are at least going to have some knowledge of what this is all about. Okay, so they won't be coming in blind. They'll understand a little bit about the language and the idea of burden shifting and all that. There's been some discussion of whether you should require certification of voluntariness and appropriateness at the time of a rezoning or PCA application. That's tricky, okay? So that's why I have a maybe there. There would have to be a very clear understanding. So just using boilerplate language and having it be a form that they sign off on is possibly not going to suffice as evidence in litigation that this was actually voluntary and appropriate, okay? We usually don't put a burden on an applicant in a public process to certify and make sure that what they're doing is voluntary and appropriate within the confines of the law. That's the job of the government, right? Like that's the job that's on your side. So, you know, it can't hurt maybe to have that in place, but you'd also want to be sure that you're not putting any language in there that says that they're waiving any of their legal rights or anything like that, okay? Or that they're certifying to you that the proffer is enforceable or anything where they're required to make some kind of legal judgment. There's actually been Attorney General opinion that was from, I think, 1989 that said, you know, you can't put this within a proffer application, something where they're waiving their ability to do something in the future, okay? So if you go down that route, you know, just as sort of a cautionary maneuver, recognize that it might not buy you everything that you want if litigation actually ends up happening, okay? It's going to come down to the actual behavior, the communication, what was done. All of that is going to also be able to be entered as evidence if something happens. Limitation of communication between staff and the applicant and or training. I've mentioned this a couple times. Yes, okay. You should make this a part of training for experienced staff as well as for anyone that you're bringing on new. And again, this, you know, when we say suggestion or requests or recommendation, that's both formal and informal. It's written and verbal. So that's a, you know, again, it's a very low bar. All right. It could even be like a nod of the head, for example. Like you don't want to have a developer say, okay, if I did this, would this be enough? And then have someone wink, like that would be the sort of the Hollywood version of this. So just, you can explain to the developer that, you are studying the impacts of something, and you can certainly, communicate what those impacts are so that the developer can appreciate, what they might have to do. But it really ends with that, okay? And again, you can explain to the developer what, why your negotiations with them, which might have had a very sort of familiar tone before under the past Proffers governance system here, that it's going to be different moving forward. And then lastly, strategy 4 is, this is going to apply to all of you. You need to plan ahead. Obviously, there's a gap that's going to exist now in terms of the things that fall outside the public facilities provision of the statute, that proffers related to affordable housing or, again, soil erosion or other things are not within the ambit of this anymore. And so, you'll need to figure out policies and programs that maybe you haven't looked at before, that can kind of make up for this shortfall. And if there's a high enough demand, I think that would be something that would be highly appropriate for another webinar, is to talk maybe about the strategies that you've used and that are out there for kind of filling some of this gap. And then in a more general sense, you would need to be prepared for the possibility that there might be litigation, okay? Or that, that you're going to have to be able to support that financially, or that there might be less dollars flowing from cash proffers. I know historically in most localities, cash proffers are a pretty small percentage of how you cover your capital needs each year. But it doesn't mean that it's not, that it's not important, that it's not something that is relied on. So just as you were conservative with how you're dealing with the proper process for these kinds of rezonings and PCAs, you would also want to, kind of think through a worst case scenario. What if we don't have this source of revenue now at all? Okay. So with that, I will wrap up here. My contact info is listed on this slide. I'm happy to be contacted by email or by phone. Again, in terms of like more fact-specific inquiries, I can help you with how you should maybe phrase questions or what kinds of things you might want to talk with your local attorney about. But I would always defer to them in terms of their ability to understand the history of your community, how you've used proffers, what you should be avoiding, and maybe to be available to provide training to your staff. There's someone that you should really be leaning on for this. The last thing I will mention is that a lot of the research that I do relates to how state laws actually affect local governments. Surprisingly, this is not something that's really well understood in planning or in public administration scholarship. And this is obviously important to know like how these changes actually impact all of the work that you do. So I'll likely be in touch with a lot of you over the coming year. And I'd also invite you to just share your stories with me. Communication is going to become very important under the new Proffers bill, figuring out what's worked for one community and whether it can be applied in yours. All of you, tend to do that already, right? We look at what our neighbors have done or what localities like us have done. Like, this is something we commonly do. And for something like this, where there's so much flux in place, it's going to be important to be sharing best practices. And I think communicating with all of you and trying to get as much of that as possible in one place and sharing it outwardly again over the coming months and years will be very helpful. Okay, so thank you for listening to a primer on proffers. I'm happy to take any questions now.
And this is Martina again. Thank you. Again, just a reminder, we have a couple questions coming in, but if you do have questions, feel free to type them in your question box below. And Tom, if you want to leave your contact screen up in full mode, you can. I'll read it so people have it if they need it. Okay, our first question is from Eldon James. Do you Do you know how many localities have changed proffer policies? How many have stopped the use of cash or on-site proffers?
I don't have numbers on percentages. Just thinking about like how many of the independent cities have or incorporated towns or counties. I know anecdotally when I've been reading about this, I guess the problem is you only read about the times when they're making changes, right? It's not really newsworthy to say like, well, we're not changing anything. But my sense in talking to planners is that this is something that has led to changes. And the biggest one is in that change to communications. That's sort of like, really the easiest thing you can do in a way. It's sort of like the first pass you should take at changing things is how you actually communicate with developers, because that's going to be what opens you up to litigation or not. And at least until these other things like, specifically attributable and some of these other terms are more fleshed out, it's understandable why you would need to err on the side of caution. One thing I haven't seen discussed as much, and maybe some of the people in the webinar audience can chime in on this, is whether you've changed how you are going about estimating the impacts to your public facilities. And I've heard about some attempts to maybe sort of narrow in and go to a smaller scale, which is something that I mentioned doing. So instead of doing a whole county, you try to do it for sub areas of the county. But even in that case, it would need to be specific to that development, to that attempt at a rezoning or a PCA. So it's hard to say whether that would actually work. So I think that's a good question, Eldon. Again, this gets back to me kind of continuing to reach out to all of you and figuring out exactly what the response has been. If there's been absolutely no response and you're just sort of waiting to see what will happen, that's not a good idea. There's enough language within the statute that, even at a baseline plain meaning interpretation of the statute, you would know how to avoid certain bad outcomes, right? Like there's enough language in there and enough understanding of what the standards have historically been to at least be able to exercise some caution in this area. So if there's a non-response anywhere, then that would definitely be a concern. But I haven't really heard about any place that's just sort of taken a blasé attitude. I think this has at least put everyone on high alert. I know it was controversial when it was passed, and that you couldn't really have a conversation with planners or anyone related to the administration of this without it coming up as like, what does this all mean? So I would guess it's a pretty high percentage that have at least taken into consideration some kind of response to this. And most of the changes that I have been able to see that there's records of from meeting minutes and things, they happened within like July or August of last year. So it was a pretty fast response too, especially in the places that were somewhat more reliant on maybe revenue from cash proffers or that had a lot of development pressure.
All right. Our next question is from Leslie Tate, and it is, what about planned unit developments, PUD rezonings, which come with a master plan and set of the development zoning regulations, setbacks, height, etc.? Are these considered proffered conditions?
Yeah, so my understanding of it is that they would be considered part of that. I was trying to look in the statute to actually see if there's like a specific exception for that. But I don't sense that it's really clear on that front. So again, I don't want to say like this is a wait and see sort of thing, but the language for what is a rezoning and PCAs is pretty broad. So this might be a case where the legislation just didn't really think that through, right? The people that put it into shape. But yeah, that's something that I could definitely dig into a little more and see if there's any specific examples of maybe there's things within PUDs that would or would not be covered. My sense right now is that it would be.
Okay, and then our next question is from Leonard Wolfenstein. I hope I pronounced that right. What are the prospects for repealing this legislation?
Yeah, that's a okay. So what's tricky about how this legislation passed is that it wasn't one of these cases where the development community was completely for it and every locality was against it, right? This didn't like split purely along like private interest and public interest. You had some localities that were in favor of this and many that were not. And then you also had some developers who were generally against this. And the reason that they were against this, I think we all understand that when you're doing a development, the thing that's worst for you is uncertainty, right? And this did introduce a level of uncertainty that maybe wasn't there when you'd have like a cash proffer schedule, right? Like it's very clear what you're going to have to do. So in terms of repeal, it's hard to read the tea leaves on that. I'm not really connected enough with the people, at the state who would be involved in trying to get this to go through, or like which legislators you would want to target to try to get them to push something through. But I think this is where it's important to be gathering a lot of evidence about how this actually is impacting you, and to try to involve developers in being able to articulate why it's impacting them as well. Supposedly the reason that this all came to be is that there was this perception, and not to call out specific regions, but related to, especially up in Northern Virginia, very high cash proffer amounts, and that there was some kind of unfairness that was resulting from these being in place. I don't know if that was fully the reason why this went through, or if there was sort of something bubbling under for years before that. It's hard to say like the motivation for a single piece of legislation and what really kind of pushed it through at the final moment. But it did have widespread support, but I would suggest that a lot of that support was kind of based on maybe incorrect ideas of how the process worked and what was fair and what was reasonable and what wasn't. I think there were likely very few cases where the per unit cash proffer schedules that were in place were totally egregious. Maybe the estimations were a little bit high, but I don't think there was ever this total disconnect from what the reality of the impact was, simply because the prior proffers law, the cases that had gone through in Virginia wouldn't have really allowed for that to be the case anyways. There always had to be this reasonableness that imbued the proffer process. And my sense is that communities were well aware of that, and that's why we weren't seeing a lot of litigation in that area, at least since the 1990s. So the other concern with this, maybe not complete repeal, but I think there might be wiggle room to try to get parts of this repealed where there's not a good understanding among the legislators of how this actually impacts the process and how it's probably very adverse to developers. Specifically the part on burden shifting and the part on communications and this idea of a mere suggestion verbally being a problem, right? To me, there doesn't seem to be much of a basis for why you would need to take that kind of drastic step. It suggests that there was an abuse going on in the system previously, that again, the past legislation and the jurisprudence flowing from that would not have really allowed for there to be. And so that seems like it's something that should be, maybe targeted for reform if we wanted to go for sort of a piecemeal approach to this. The other thing that I would suggest is that list of what counts as public facilities. It's broad. It covers a lot of the things that were sort of tackled before, and that proffers were already being used for. But I think what it fails to recognize is that in some communities, the use of proffers related to affordable housing or related to erosion, that there were proffers needed for very specific reasons that had to do with impacts that were very real from development. That these weren't just sort of specious things that were being drummed up as ways to get extra money off of residential real estate developers. So maybe targeting that for expansion, at least in communities where where certain thresholds are met, where like these sorts of impacts are likely to be more of a burden on a community. And then looking at that part about communications and seeing if specific changes can be made to that language. So maybe allowing informal communications and negotiations to not be part of a problem here, and then shifting that burden so that it doesn't make it so easy for an applicant to bring litigation.
All right, I have one last question at this point, and we're pushing right up on 1 o'clock, so bear with me as I read it. It's from Alex Long. It would seem the first developer to harvest existing capacity benefits and then the next developer following. If capacity is diminished, then pays for that capacity. However, is it possible that a locality would have to give all development proposals benefit of existing extra capacity, even if approval of those developments effectively abolishes all existing capacity, but in the future?
Okay, so you're saying there's existing excess capacity, and now we have a case where developers are going through and taking advantage of that because, if we went back several slides, there was that idea of that it had to be in excess of existing capacity, right? So like all the developers will continue to be advantaged until we get to the magic threshold where existing capacity is met, and then suddenly we have this being triggered. Yeah, I mean that's something that could definitely happen. I'm just gonna go back to that slide so that people can see sort of what we're looking at here. Yeah, so it's this aspect of unreasonableness where an offsite proffer has to respond to a need or identifiable portion of a need in excess of public facility capacity. Yeah, so again, something, I guess with regard to this question, yeah, that is going to be a real possibility that comes out of this. It's the one thing that's tricky about the legislation is that there wasn't really any clarification in there about timing of all of this, right? Like when we say in excess of public facility capacity, is this based on, it says existing at the time of rezoning or PCA, but obviously, there's a lot of consideration of future capacity when we're thinking about how we deal with development. So yeah, that I would say that does seem like it's going to be an obvious problem that arises from this. And maybe this is one of those cases where, in terms of advocacy about repealing this or reform, there needs to be some kind of way to have data about this, how developers are using this provision, how they're actually using the public facility capacity, and what happens when we get up close to that threshold versus over it. I would say, remember that public facility capacity, that part about it existing at the time of rezoning or PCA. There is a provision in there about like when we would actually be looking at what that baseline is.
All right. I don't think I have any other questions that have come in. And as always, we encourage our listeners to reach out to our presenters via email or phone, whatever works best for you, Thomas, if there are any follow-up questions. Again, we will post this recorded session on our YouTube page. We'll send out an email within 24 hours of it being posted and where you can access it and share it. Again, thank you to the Berkeley Group for making these monthly webinars possible. They're always the fourth Monday of every month from noon to 1. Usually we would know what our September title is. We have a presenter. We're just nailing down the actual title, but we should be able to get that out to you within the next couple of days as well. So we hope you will join us next month. And as always, if you have any questions, please contact the chapter directly. And all of that contact information will be in your email as well. Again, thank you to Thomas and to Virginia Tech and to everyone who took their lunch hour to spend with us. We really appreciate it, and we look forward to talking with you guys next month. Thank you.